Hi, this is Zahour from SM JUROR, and today we're going to be looking at the juror misconduct issues in the case of Jones versus State. Some points that I want to highlight that we're going to discuss are juror letters to the trial court, juror bias, and prohibitions under Rule 606B. In this case, defendant Jones was convicted of second-degree sexual abuse of a minor for having sexual intercourse with a 15-year-old girl. A majority of the opinion discusses defendant's various challenges to jurors during jury selection, but we're going to focus on the alleged juror misconduct issue in the case. There were two defendants in this case, and they sought to remove juror RC for cause. When the trial court ruled against them, they chose to leave RC on the jury. 2 weeks after the jury verdict, defendant's attorneys filed a motion for new trial. The relevant issue for our purposes was that they argued that RC had a quote-unquote significant undisclosed bias, as documented in 2 letters from other jurors who described what occurred during jury deliberations. Those letters revealed that during jury deliberations, RC called the defendant a pervert, gambler, and predator who would likely commit the crime again. Additionally, one letter revealed that after the jury contacted the bailiff to inform him that they reached a decision, RC had indicated that his son had spent time in jail for the same exact issue. Now, when we look at the denial of the motion for new trial, the trial court denied the motion for 2 reasons. First, the judge ruled that Evidence Rule 606B barred him from considering the 2 jurors' letters. Second, and in the alternative, the judge ruled that even if the law allowed him to consider those letters, the letters did not prove that juror RC reached his decision based on anything other than the evidence presented at Jones's trial. Now, with respect to Evidence Rule 606B, it barred the trial judge from receiving any evidence from the 2 jurors or any other jurors regarding these matters. And that's because, under the rule, a verdict generally cannot be impeached by evidence that jurors made improper remarks during or following deliberations, although the rule makes exceptions for extraneous prejudicial information improperly brought to the jury's attention or outside influence brought to bear upon any juror. Now, when we look at the holding in this case, with respect to defendant Jones, the Superior Court concluded that the alleged jury misconduct did not fall within either of these 2 exceptions, and that Evidence Rule 606B therefore prohibited Jones from relying on the jurors' post-trial letters. The Court of Appeals agreed, and they found that there was no error and that the trial court did not abuse its discretion when it denied the motion for new trial based on juror misconduct. Now, let's look at the specific facts which were pivotal to the outcome of the case. First, Jones made no claim that juror RC lied during jury selection. Rather, Jones's motion for new trial was based solely on the content of the 2 jurors' post-trial letters. Because Evidence Rule 606B barred the court from receiving evidence from the jurors regarding these matters, the trial court correctly denied Jones's motion for a new trial. And second, the defendant claimed that juror RC based his verdict on emotion rather than evidence, but there was no evidence to support that claim. It was pure speculation, and as we know, speculation does not equal evidence. And that's it for our case law analysis of the juror misconduct issues in this case. Again, this is Nilgün Zahour from SM JUROR. Thanks for watching. Because the only evidence you want the jury to consider is in the courtroom. See you next time.